Hello, this is Dane Ciolino, and welcome to Moot Court Lawyering 2 and this discussion on basic advocacy and rhetoric principles. This is your first class on persuasion in law school. Last semester, you all talked about writing and research, but in the context of making a more dispassionate exposition of what the law is and what your client's chances are of winning with this argument or that argument. You evaluated the strengths and the weaknesses of arguments and authorities. But that's what we are going to do. We're going to do something a little different this semester. This semester, we're talking about persuading. We're not just going to write documents in an effort to explain. We're writing documents to persuade. We are going to orally, in our exercises throughout the semester and in your final oral arguments toward the end of it, we are going to use oral advocacy to persuade. It's all about persuasion. And what I'm going to do in this brief video lecture is to talk to you about the history of persuasion and some of the basic approaches to persuading a listener to see the facts or to see a legal case your way rather than the way that your opponent would like them to see it. Kind of one of the starting points here is that decision makers are not computers. And by decision makers, I mean an arbitrator to whom you might be making an argument. I could mean a jury. I could mean a judge. But in the context of this class, the decision maker is going to be an appellate judge, typically a panel of 3 or more appellate judges. That's who you are going to try to persuade that your arguments are right. Now, we'll also have a trial judge that we're going to try to persuade early in the semester. But what I'm saying really doesn't matter who the person is you're trying to persuade, who the decision maker is. They're not going to be computers. They're going to be thinking about a lot of other things while you are trying to make your argument orally, while they are reading your brief or reading your memorandum in support of the motion. And here, this Homer Simpson cartoon thinks he's thinking about donuts and beer and sex and sleeping rather than what's happening before us. We all spend a lot of time daydreaming and thinking irrationally and making irrational decisions. We know that we shouldn't eat that Cheeto. It's fluorescent orange. It's not good for us, but we eat it anyway. So people make decisions for a lot of illogical, wrong reasons. And that's important to keep in mind when you are writing your brief and making your oral arguments, is that the decision makers you're presenting these to view the law and the evidence through their personal experiences. They are busy. They don't have that much time to devote to reading your brief. They have very short attention spans and a very wandering conscience, if that's the word, a wandering attention, where they're thinking about all the things that Homer Simpson's thinking about. But they usually want to do the right thing. So what we're talking about, these principles in this lecture, are some of the things you need to think about to persuade the non-computer decision maker. And a lot of what I'm talking about is not new. Nothing that I'm going to talk about is new. In fact, what we're discussing here is rhetoric. The field of rhetoric has been around since the 4th century BC. Most famously, Aristotle wrote a book on rhetoric, and much of of what he said back centuries ago, millennia. For example, your arguments have to have logical sense. That is, there must be logos. What does that mean? Well, more on that later, but you must appeal to the head of the decision maker. Your arguments also, to be persuasive, must have pathos or emotional appeal. If logos appeals to the head, pathos appeals to the heart. So when you are crafting your argument, make sure you craft one that considers pathos. And then finally, your argument must have ethos or personal advocacy. Put another way, it's not only the message that matters, it's the messenger. You are the messenger, and you need to keep in mind that jurors, and in our case, the decision maker, which is a judge or a panel of judges, is looking at you and evaluating your arguments in light of who you are and how you appear. And by you, I mean you in your oral presentation or you in your written product, namely the brief or the memorandum. Okay, so what should you think about in crafting a persuasive argument? Well, a persuasive argument, first of all, you start with rule one, and rule one is use personal advocacy. You can't take yourself and separate yourself from, certainly not your oral argument, because there you are in person or on Zoom, since so many arguments nowadays are done by video conferencing. There you are, so you have to use your own personal advocacy to sell your arguments. But also in your brief, you can look at a brief. Is it sloppy? Does the person use good cite form, good grammar? Do they write well and succinctly? That all speaks volumes about who you are and whether you are a trustworthy and knowledgeable advocate. So you've got to use yourself and keep that in mind when you're making arguments. Okay. So if rule one is use personal advocacy, how can you do that? Well, there are a number of, you can see the Latin roots in this that go back to rhetoric principles in antiquity, but decorum. You want to appear conservative in appearance. You want your briefs not to be flashy. You don't want to use smiley faces, icons, and purple print. You just want to be very, very conservative in appearance. You want to send off the messages that you are essentially a person in the mainstream. You are a lawyer who is well respected, and you're real. You are not appearing to be anybody. You are a person who is just respectable. Virtue. You want to show respect for the court. When you stand up, you want to say, "May it please the court." You want to, in the language that you use in your briefs and other filings, again, be very respectful, not just of the court, but also of your opponents. Don't say, "My opponent's an idiot." No, that doesn't demonstrate virtue. You want to make it very clear to the decision maker that you are respectful of the court. You're taking reasonable positions. You are not embarrassing anyone. Disinterest. You want to appear as someone who wants to get to the right result. And if the right result is you win, well, don't gloat about it. Just say, "Look, I've considered," you wouldn't say I, but you can consider this argument and that argument, Your Honor, but after you consider them all, my client's really got to win this. And again, you're not jumping up and down saying you're clearly right. You're essentially saying, my client's argument is the best, and it's just got to be that way given the facts and the law. So again, that just shows that you are a reasonable person, not a person who's, by reasonable I mean a person who's coming at this using reason and logic and experience, rather than a person who's coming at this as a win at all costs advocate. And finally, you really want to exude that you know what you're doing. Now, this is one of these, you want to both be and seem to be a person who knows what she is doing. And how do you know your case and your argument? How do you exude expertise? Well, you have to show that you have a command of the record and the facts, a command of the testimony, if it's transcripts, a command of the documentary exhibits and the law. So this comes off with people, obviously, when they're making oral arguments, but also when they are writing briefs. Be the person who knows what they're talking about, and you only know what you're talking about through careful preparation, study, and whatnot. Okay, so you're going to use personal advocacy in all of your efforts to persuade. You also need to use a central theme. And by a central theme, I mean, this is the Rosetta Stone. And again, we all know what this was, right? This was the stone that allowed, I imagine it was British archaeologists to figure out what Egyptian hieroglyphics meant. Again, I don't know or remember much more about the Rosetta Stone other than that, but the term Rosetta Stone is one that has become just a euphemism for kind of a way to figure out what something means. So decision makers want to get to the right result. You need to give them kind of an organizing construct, something that they can use to solve their questions and problems as they go through. So how do you develop a central theme? And the central theme is why you should win this case, why your argument should be accepted by the decision maker, not the arguments being put forward by your opponent. Well, again, you've got to consider logos, pathos, and ethos. You need to appeal to the decision maker's head, heart, and you have to have the decision maker believe that you are knowledgeable and credible about the case. So how do you work logic in here, in developing the central theme about your case and persuading? Well, you got to make sure your arguments are logical. Now, I know I've just used the word logic to define how to make something logical, but you kind of generally get the point. You've got to present the facts and arguments in some rational order. Now, with the facts, it's usually pretty easy. You're going to do it chronologically in the fact section of your brief or your memorandum. Arguments, again, it's hard to talk about this in the abstract, but arguments need to be constructed in a way that has a, for example, outline format. Roman numeral 1A, 1A, 1, 2, 3. You know how you structure headings using outline format. You're going to want to do that in that rational order because it shows that you understand how, as a matter of categorical organization, you are putting the arguments where they belong. Now, this is really just another way of saying you need to organize your written materials and your oral arguments in a way that makes sense. Now, years ago, someone told me, this was actually in a book, that there are only 5 ways to organize any information. And those ways are chronologically, alphabetically, by some physical attribute like height. So, for example, well, that's the third way. The fourth way would be by geography, and the fifth way would be by category. So how might you do that in kindergarten? Well, the kindergarten teacher might say, okay, let's all line up from Mr. Adams all the way through Mr. Zimmerman, alphabetically. Okay, or everybody can line up from the smallest to the tallest. That would be another way. Another way is we could have all the people from New Orleans over here, all the people from Metairie over there, and all the people from Chalmette over there, geographically. We could also do it categorically. We could just come up with some category, for example. Now, the other one would be chronology by age. We could oldest to youngest, or vice versa. But we could also do it categorically. For example, we could decide all of the people with type A blood could go over here, and all the people with O negative over there, and AB positive over there. You, in legal discourse, will generally use two of those methods to organize all information in your arguments. Generally, you'll use chronology when you are talking about the facts, because that's the way you usually would do it. But your arguments are going to be made categorically, and you need to show those categories by using the traditional outline format for your headings. That shows how all of the categories of arguments fit with one another. So you want this, whatever you draft, to just exude that it's rational and it's well thought out and well ordered. You want to source your facts to exhibits, transcripts, and record contents. Very important to do. Why? Because it shows that you're not just saying these things. You're not just saying the light was red when your opponent's client ran through it, but you're citing to witness statements. You're citing to videos, documents. That, again, helps as a matter of logic, but it also helps as a matter of personal advocacy. It shows that you're a person who's prepared, and you are making logical statements about the facts, and you're sourcing them to where they came from. And then you also need to source your law to specific authorities, cases, statutes, constitutional provisions, secondary authorities like law review articles, treatises. You don't just want to say what the law is, you want to show the authority that supports the assertion of what you say the law is. You do all of these sorts of things, you're appealing to the person's head, that you're showing them that there is support for what you're saying, and everything fits together. If it just fits, it's got some logic underlying it. People, though, aren't computers, as we've already said. People often make decisions with their hearts, not with their minds. And Aristotle said that people were more akin to making emotional decisions than they were to making logical ones. Now, often people make an emotional decision and then logically justify their decision, but they start with their gut. So how do you appeal to someone's heart or their gut? Well, you want to lay out the facts, for example, in a sensory manner. Like if you are representing a plaintiff in a car accident case, you might want to set the scene by having it happen on a fall day as the car is rolling over the leaves, and the leaves are rustling as the car went down the street. Somebody is in an accident, and you might describe the sound of the accident. Again, you can't make this up. It's all got to be supported by what a witness has said. But it gets the person there. It takes the decision maker out of the chambers of the judge and puts them out there on the street where the person is dying in the cold and bleeding, and you could smell the blood and the gasoline spilled on the street. You want that gets them more, the decision maker more into the scene and gets them to respond emotionally. You need to figure out how you want the reader to feel. Do you want them to feel sorry for your client? Do you want them to feel angry at the defendant? Now, I had a lawyer once years ago come talk to my trial advocacy class, and he said, if you want to get a really large verdict from a jury, make them feel sorry for your client. But if you want to get a shit ton of money, make them angry at the defendant. Now, excuse the language there, but that's his language, not mine. And just keep in mind that you should think about this. Again, it can't be really overt. It's got to be something that's, and all these appeals to emotion can't be overt. They have to be just kind of baked into what you're doing, into your oral argument or into your written word. And you know, use simple language, underplay these sorts of things. The more you overtly play your hand here, the less persuasive it's going to be. And by using simple language, this is true not only for emotional appeal, but just for good writing. You know, keep your sentences short. Describe things simply. Like, for example, rather than saying something like, the car was exceeding greatly the speed limit when the child was struck crossing the street. No, it's much more emotionally appealing and even understandable to say, the defendant was driving the car, the defendant wasn't paying attention, and the little girl's ball rolled into the street. And she ran out after it. Just then, the defendant looked up from his phone. It was too late. He killed her. Well, you know, again, that's more emotionally appealing than the way that more convoluted way that I put it before. Use simple language and underplay it. And by and large, tell a story. You know, a story has a beginning, a middle, and an end, as they always say. You have to get the listener interested in your client and in your case, invested and interested in what is going to happen next. And you've got to make your client the hero of the story. That's what gets people emotionally to respond. We as humans are hardwired, or at least we have thousands of years of evolution that makes us want to hear stories and understand stories. That's why we tell stories in movies and in TV. That's what it keeps our attention and gets us engaged. We cry when we see a story that is sad. So tell a story. And to tell a story, set something up. And by setting something up, I mean some tension that needs to be resolved. The best simple description of this was by one of the movie makers in MGM, Metro-Goldwyn-Mayer. I don't know, remember which one it was, but he says a movie's pretty simple. You introduce a hero, you run him up a tree, and you get him down. Well, there you go. The beginning, this is who my character is. You run him up a tree. How are we going to get him down? How are we going to get him down? You get him down. And there it is. Think about that when you're constructing your arguments. Introduce the issue, put it up in a tree, and get it down. Tell a story. Okay, so in developing a central theme, you need to consider logos, pathos, and ethos, as we've just talked about. You've got to make your central theme, why you should win, simple and internally consistent. Now, this is tough for lawyers because lawyers love the buffet. Where, you know, a buffet, you push your tray down and you get yourself some peas and some meatloaf, and then you get yourself some mashed potatoes. Yeah. And lawyers do that with arguments. They say, I should win for this reason, and that reason, and that reason, and that reason. Avoid that. Don't make arguments in the alternative. Like, for example, my client wasn't in the bank. He was at his mother's house. But if he was mentally incompetent. He was insane and didn't understand the difference between right and wrong. Now, can lawyers make arguments in the alternative? Oh, sure you can. Should you? Well, Not if you can avoid it. Because a person who makes arguments in the alternative is a guy who's just trying to sell you a watch out of the inside of a coat on a street corner. He doesn't care about anything other than making the sale. And you can't, as a matter of personal advocacy, be that person. And plus, if you've got a good argument, once you start compounding and putting another argument on top of another argument, they all become less persuasive, particularly that really good one at the beginning. So don't accumulate. If you got 5 arguments, make 3. Better yet, make 2 or 1 if you can even do that. Don't accumulate. Give away what you can't win. There's nothing I like more than giving away something by saying, you know, my opponent is right about this. That's good for you. It shows that you're fair. Also, you're going to lose it anyway, so give it up and get some personal advocacy points from it. And also, it shows that you are respectable, that you're not wasting people's time. If they're right, say it, and say it unabashedly. It shows that you're not scared of it either. And finally, and most importantly, and something we're going to talk about in the next slide, account for all facts and all law. Every case is a case because it's got some good facts and some bad facts. Or on appeal, because there's some good law that helps you and some bad law that doesn't. You know, if all the law was good and all the facts were good, it wouldn't be a case, and vice versa. So every case, every dispute, because it's a dispute, has some good and some bad. And you need to account for them all. And in this regard, there are 4 levels of fact and law accounting. And the first is the worst, which is kind of a let's pretend approach to all of this, where you just, your client was drunk and driving down the street and he hit a little girl. Well, let's pretend would be just kind of saying that he was on the way to church. Well, he wasn't. He was going from one bar to another. He told that to the police officer. So where are you coming up with the church? You made it up. That's a fool's game. You can't pretend. You can't make, I can't tell you how many times I've had cases where I wish I could have made the facts, but we don't make the facts. We don't make the law. But we can't, and if we do, if we're making up facts and law, we're fools pretending. So don't do that. Another level of fact accounting is at least you're dealing with what you got. You're not making stuff up, but you're trying to ignore it. So if your client was driving from one bar to another bar and he was drunk and he hit the little girl, an ignorance of bliss approach would be where you just kind of ignore that he was drunk. You stand up and you make the arguments, he was driving, and then the finder of fact would go, or the decision maker, counsel, wasn't your client drunk at the time he hit the little girl? Yes, he was, Your Honor. Well, look at that. That is a fact. Your client was drunk. Deal with it. Don't just cover your eyes to it, stick your head in the sand like an ostrich. The fact's not going to go away. Now, the next level would be inoculation and explanation. This would be, for example, telling the fact finder, Your Honor, my client was drunk when he was driving down the street. No doubt about it. No doubt about it. But let me tell you why he didn't cause the accident. Well, and then you go on and explain that the little girl darted out from behind a tree. Nobody, sober, drunk, could have avoided the accident. So yes, he was drunk, but it didn't contribute to the accident. Well, at least you've inoculated the fact finder, you've explained it. And that's better than making stuff up or ignoring the bad fact. At the very least, the bad facts, the bad cases, the bad statutes have got to be acknowledged and explained by you. Because remember, Your other side, your opponent is going to be mentioning all the bad stuff and putting their own spin on it. You need to put yours on right out of the box. And then finally, the level of accounting that we all hope to is the master's game, where you take the bad facts, or the seemingly bad facts, and through legal jujitsu, jujitsu is a martial art where you use your opponent's weight against them. Well, here, if you can take the bad facts and turn them into your facts, your good facts, then all the better. Now, you have to do this in a way that makes sense, where it doesn't, there's a fine line between the master's game and let's pretend. But, for example, let's say that your client was drunk and he was driving drunk when he hit the little girl. What can you do with that? Well, it's a bad fact, right? But you can do something with it, perhaps. Maybe you're trying to say that your client, and again, it's hard to not turn this into a game of let's pretend. Maybe you can say your client was drinking, and the drinking caused him. Again, it's really hard to do this without turning it into let's pretend. But if you could somehow turn that into a good fact, maybe he was rushing out of the bar. He had planned to spend the night at the hotel bar, but he was drunk driving because he had to rush and take his old grandmother to the hospital. Well, of course he was drunk. He was drinking, and he, at that point, had to rush and go get her. He assumed that he wasn't so drunk that he couldn't drive. Now, maybe we're inoculating and explaining, but we're taking the drunkenness and turning it into a good thing, because he just said, everything be damned, I've got to get my grandmother to the hospital. Again, be careful here, but it is something that you need to think about. As to each bad case that you have to deal with, each bad fact, is there any way that I can turn this into something that's helpful rather than just trying to explain it away or ignoring it? All right, well, those are just some basic thoughts. Now, how do you work this in to a brief, to an oral argument? Well, you just need to sit back and think. On a large scale, I am going to try to persuade this person. What can I do by way of personal advocacy, by way of logos and and pathos? What can I do to construct the most logical, emotionally appealing argument that I can, and to present it in a way that makes me credible and knowledgeable? If you at least keep all of that in mind as you do this, it's going to go a long way toward making you as persuasive as you can be.